Good evening, everyone. We are the Group 9 and we discuss the Republic Act number 11232, the special type of corporation. And we proceed to the Title 11, Non-Stock Corporation. Let's proceed to Section 87, Definition. For the purposes of this code, a non-stock corporation is one where no part of its income is distributable as dividend to its members, trustees, or officers, subject to the provision of this code on dissolution, provided that any profit which a non-stock corporation may obtain as an incident to its operation shall, whenever necessary or proper, be used for the furtherance of the purpose or purposes for which the corporation was organized, subject to the provision of this title. Because the mere realization of profit out of the operation of a non-stock corporation does not automatically result in the loss of its exemptions from income taxation, as long as no part of its profit ensures to the benefit of any stockholder, member, or individual. In addition, many non-profit that are also non-stock corporations usually have members, but these members are not owners in the strict sense. They don't receive any money received by the company due to its non-profit status. Non-profit corporation may also have a board of directors and paid executives and staffs. Since non-stock companies are separated business entitles, the general member and board members have their liability protection as shareholders, director, and executive of stocks corporation. Because the biggest reason business owner choose non-stock corporation status is to take advantage of non-profit or tax-exempt status from the IRS. And some of the most common types of non-stock corporation are labor organizations, civic legends, business legends, recreation clubs, athletic organizations, education organization, municipal corporation, and mutual insurance companies. Section 88 purposes. Non-stock corporation may be formed or organized for charitable, religious, educational, professional, cultural, fraternal, literary, scientific, social, civic service, or similar purposes like trade, industry, agricultural, and like chambers, or any combination thereof, subject to the special provision of this title governing particular classes of non-stock corporations. To qualify as a non-profit organization, your corporation, fund, foundation, or community chest must be created, organized, and operate for one of these purposes. And next, Section 89, Right to Vote. The right of the members of any class or classes to vote may be limited, boarded, or denied to the extent specific in the Articles of Incorporation or the bylaws. Unless so limited, boarded, or denied, each member, regardless of class, shall be entitled to one vote. If you are a member of non-stock corporation, you have the right to vote. However, limited, boarded, or denied to the extent specified in the AOI or bylaws, unless otherwise provided in the Articles of Incorporation or the bylaws. A member may vote by proxy in accordance with the provision of this code. Voting by mail or other similar means by members of non-stock corporation may be authorized by the bylaws of non-stock corporation within the approval of under such condition which may be prescribed by the Security and Exchange Commission. Section 90, Non-Transferability of Membership. Membership is a non-stock corporation and all rights arising therefrom are personal and non-transferable unless the Article of Incorporation or the bylaws otherwise provided. Section 91, Termination of Membership. Membership shall be terminated in the manner and for the causes provided in the Articles of Incorporation or the bylaws. Termination of membership shall have the effect of disgusting all rights of the member in the corporation or in its property, unless otherwise provided in the Article of Incorporation or the bylaws. And if you are a member of non-stock corporation, its membership is non-transferable unless otherwise stated, and termination of membership will be in the manner and causes provided in the AOI or bylaws. And however, doing this will extinguish all rights of the member unless otherwise provided. Section 92, Election and Terms of Trustees. Unless otherwise provided in the Articles of Incorporation or the bylaws, the Board of Trustees of non-stock corporation, which may be more than 15 in number as may be fixed in their articles of incorporation or bylaws, shall, as soon as organized, so classify themselves that the term of the office of 1/3 of their number shall expire every year. And subsequent election of trustees comprising 1/3 of the Board of Trustees shall held annually, and trustees so elected shall have a term of 3 years. Trustees thereafter elected so file vacancy acquiring before the expiration of a particular term shall hold office only for an expired period. And no person shall be elected as trustee unless he is a member of the corporation. And the last one is unless otherwise provided in the article of incorporation or the bylaws, officer of non-stock corporation may be directly elected by the members. And for the trustees and officers, election and term of trustees is Board of Trustees may be 15, classify themselves that the term of office of 1/3 of their number shall expire every year. And for the following elections and trustee, they are 1/3 annually. And to those elected will have a term of 3 years. And only members of the corporation can be elected as trustees, because officer of NSC can be elected directly by the member unless otherwise stated. And for the Section 93, Place of Meetings, the bylaws may provide that the member of non-stock corporation may hold the regular or special meetings at any place even outside the place where the principal office of the corporation is located, provided that proper notice is sent to all members indicating the date, time and place of meetings, and provided further that the place of meeting shall be within the Philippines. In all, can be at any place the meeting happen, even outside the place where the principal office is located. And all members receive a notice of meeting with date, time, and place. And for the meeting place is in the Philippines only. Section 94, Rules of Distribution. In case of dissolution of the non-stock corporation in accordance with the provision of this code, its assets shall be applied and distributed as follows. First is all liabilities and obligation of the corporation shall be paid, satisfied, and disregard or educated provision shall be made thereof. Second is asset held by the corporation upon a condition requiring return, transfer, or convenience, which condition occurs by reason of dissolution, shall be returned, transferred, or conveyed in accordance with each such requirement. The third one is asset received and held by the corporation subject to limitations permitting their use of for charitable, religious, benevolent, educational, or similar purposes, but not held upon a condition requiring return, transfer, or convenience by reason of the dissolution, shall be transferred or convened to one or more corporation, societies, or organization engaged in activities in the Philippines substantially similar to those of dissolving corporation according to a plan of distribution adopted pursuant to this chapter. The fourth one is asset other than those mentioned in the preceding paragraph, if any, shall be distributed in accordance with the provision of the article of incorporation or the bylaws, to the extent that the article of incorporation or the bylaws determine the distributive rights of members or any class or classes of members, or provided the distribution. The last one is in any other case, asset may be distributed to such persons, societies, organization, or corporation, whether or not organized for profit, as may be specified in a plan of distribution adopted pursuant to this chapter. Section 95, Plan of Distribution of Asset. A plan providing for the distribution of asset not inconsistent with the provision of this title may be adopted by a non-stock corporation in the process of dissolution of the following manner. Because the Board of Trustees shall by majority vote adopt a resolution recommending a plan of distribution and directing the submission thereof to a vote at a regular or special meeting of members having voting rights. Written notice setting forth the proposed plan of distribution or a summary thereof of the date, time, and place of such meeting shall be given to each member entitled to vote within the time and in the manner provided in this code for the giving of notice of meetings to members. Such plan of distribution shall be adopted upon approval of at least two-thirds of the members having voting rights present or represented by proxy at such meetings.
Close corporation.
A closed corporation is a company whose shares are held by a select few individuals who are usually closely associated with the business.
Section 96. Definition and applicability of title. A closed corporation within the meaning of this code is one whose articles of incorporation provide that, first, all the corporations issued stock of all classes, exclusive of treasury shares, shall be held of record by not more than a specified number of persons, not exceeding 20. Second, all the issued stock of all classes shall be subject to one or more specified restrictions on transfer permitted by this title, and the corporation shall not list in any stock exchange or make any public offering of any of its stock of any class. Notwithstanding the foregoing, a corporation shall not be deemed a closed corporation when at least two-thirds of its voting stock or voting rights is owned or controlled by another corporation which is not closed corporation within the meaning of this code. Any corporation may be incorporated as a closed corporation, except mining or oil companies, stock exchange, banks, insurance companies, public utilities, educational institutions, and corporations declared to be vested with public interest in accordance with the provision of this code.
In Section 96, stated that all corporations issued from all classes, except in the divided treasury, must be kept in such a record that they do not exceed the prescribed number of persons, not more than 20.
Section 97. Articles of Incorporation. The Articles of Incorporation of a closed corporation may provide, first, for a classification of shares or rights and the qualifications for owning or holding the same, and restrictions on their transfers as may be stated therein, subject to the provisions of the following section. Second, for a classification of directors into one or more classes, each of whom may be voted for and elected solely by a particular class of stock. And last, for a greater quorum or voting requirements in meetings of stockholders or directors than those provided in this code. The Articles of Incorporation of a closed corporation may provide that the business of the corporation shall be managed by the stockholders of the corporation rather than by a board of directors, so long as this provision continues in effect. Number 1. No meeting of stockholders need be called to elect directors. Second, unless the context clearly requires otherwise, the stockholders of the corporation shall be deemed to be directors for the purpose of applying the provision of this code. And last, the stockholders of the corporation shall be the subject to all liabilities of directors.
According to Section 97, the Articles of Association of a closed corporation may provide that the corporation's business is managed by the corporation shareholders instead of by the board of directors. The Articles of Association may also provide that all officers or employees as specific executives or employees must be selected or appointed by the shareholders in place of the board of directors.
Section 98. Validity of restrictions on transfer of shares. Restrictions on the right to transfer shares must appear in the Articles of Incorporation and in the bylaws as well as in the certificate of stock. Otherwise, the same shall not be binding on any purchaser thereof in good faith. said restriction shall not be more onerous than granting the existing stockholders or the corporation the option to purchase the shares of the transferring stockholder with such reasonable terms, conditions, or period stated therein. If upon the expiration of said period, the existing stockholders or the corporation fails to exercise the option to purchase, the transferring stockholder may sell his shares to any third person.
According to Section 98, a prohibition on the transfer of shares cannot be more risky than permitting present shareholders to acquire shares, provided the company purchases them upon the shareholders' transfer on fair terms, conditions, or for a set length of time.
Section 99. Effects of issuance or transfer of stock in breach of qualifying conditions. Number 1. If stock of a closed corporation is issued or transferred to any person who is not entitled under any provision of the Articles of Incorporation to be a holder of record of its stock, and if the certificate for such stock conspicuously shows the qualification of the person entitled to be holders of record thereof, such person is conclusively presumed to have notice of the fact of his ineligibility to be a stockholder. Second, if the Articles of Incorporation of a closed corporation states the number of persons not exceeding 20 who are entitled to be holders of records of its stock, and if the certificate for such stock conspicuously states such number, and if the issuance or transfer of stock to any person would cause the stock to be held by more than such number of persons, the person to whom such stock is issued or transferred is conclusively presumed to have notice of this fact. Third, if a stock certificate of any closed corporation conspicuously shows a restriction on transfer of stock of the corporation, the transferee of the stock is conclusively presumed to have notice of the fact that he has acquired stock in violation of the restriction, if such acquisition violates the restriction. Fourth, whenever any person to whom stock of a closed corporation has been issued or transferred has, or is conclusively presumed under this section to have, notice either that he is a person not eligible to be a holder of stock of the corporation, or that transfer of stock to him would cause the stock of the corporation to be held by more than the number of persons permitted by its article of incorporation to hold stock of the corporation, or last, that the transfer of stock is in violation of restriction on transfer of stock, the corporation may at its option refuse to register the transfer of stock in the name of the transferee. Fifth, the provision of subsection shall not be applicable if the transfer of stock, though contrary to subsection of, has been consented to by all the stockholders of the closed corporation, or if the closed corporation has amended its articles of incorporation in accordance with this title. 6. The term transfer as used in this section is not limited to a transfer for value. 7. The provision of this section shall not impair any right which the transferee may have to rescind the transfer or to recover under any applicable warranty, express or implied.
According to Section 99, if a person who is not entitled to be a shareholder of a closed corporation under any provision of the Articles of Incorporation issues or transfer shares of that corporation, and the certificate for such a share meets the qualification, the person exercises the right to take it over. He is fully aware of his inability to be a shareholder.
Section 100. Agreements by stockholders. Agreements by and among stockholders executed before the formation and organization of a closed corporation, signed by all stockholders, shall survive the incorporation of such corporation and shall continue to be valid and binding between and among such stockholders, if such be the intent. to the extent that such agreements are not inconsistent with the articles of incorporation, irrespective of where the provision of such agreements are contained, except those are required by this title to be embodied in said articles of incorporation. Second, an agreement between two or more stockholders, if in writing and signed by the parties thereto, may provide that in exercising any voting rights, the shares held by them shall be voted as therein provided, or as they may agree or as determined in accordance with the procedure agreed upon by them. Third, no provision in any written agreement signed by the stockholders relating to any phase of the corporate affairs shall be invalidated as between the parties on the ground that its effect is to make them partners among themselves. Fourth, a written agreement among some or all of the stockholders in a closed corporation shall not be invalidated on the ground that it so relate to the conduct of the business and affairs of the corporation as to restrict or interfere with the discretion or powers of the board of directors, provided that such agreement shall impose on the stockholders who are parties thereto the liabilities for managerial acts imposed by this code on directors. And last, to the extent that the stockholders are actively engaged in the management or operation of the business and affairs of a closed corporation, the stockholders shall be held to strict fiduciary duties to each other and among themselves. Said stockholders shall be personally liable for corporate torts unless the corporation has obtained reasonably adequate liability insurance.
According to Section 100, agreements that are duly signed and enforced by and between all shareholders before the establishment and organization of the private company must continue after the establishment and remain valid and binding between the shareholders.
Section 101. When board meeting is unnecessary or improperly held, unless by the laws provide otherwise, any action by the directors of a closed corporation without a meeting shall nevertheless be deemed valid if: Number 1. Before or after such action is taken, written consent thereto is signed by all the directors. Or second, all the stockholders have actual or implied knowledge of the action and make no prompt objection thereto in writing. Or third, the directors are accustomed to take informal action with the express or implied acquiescence of all the stockholders. Or fourth, all the directors have expressed or implied knowledge of the action in question and none of them makes prompt objection thereto in writing.
In Section 101, any action required or permitted at any meeting of the Board of Directors or its committee may be undertaken without a meeting. If any member of the board or the committee, whatever happens shall be authorized in writing, and the document or correspondence shall be completed by a record of the activities of the board or committee. And an action within the jurisdiction of a corporation taken at a meeting held without a proper notice or notice shall be deemed to have been approved by the director who is not attending.
Section 102. Preemptive right in closed corporations. The preemptive right of stockholders in closed corporation shall extend to all stock to be issued, including the issuance of treasury shares, whether for money, property, or personal services, or in payment of corporate debts, unless the articles of incorporation provide otherwise.
In Section 102, the Articles of Incorporation state otherwise. The shareholders of closed companies have first refusal on all issues to be issued, including the reissue of own shares for money, property, or personal services, or the repayment of corporate debt.
Section 103. Amendment of Articles of Incorporation. Any amendment to the Articles of Incorporation which seek to delete or remove any provision required by this title to be contained in the Articles of Incorporation, or to reduce a quorum or voting requirements stated in said Articles of Incorporation shall not be valid or effective unless approved by the affirmative vote of at least 2/3 of the outstanding capital stock, whether with or without voting rights, or of such a greater proportion of shares as may be specifically provided in the Articles of Incorporation for amending, deleting, or removing any of the aforesaid provision at a meeting duly called for the purpose.
In Section 103, any amendment to the statutes which seek to remove or omit any provision required by this title or to reduce the quorum or vote specified in the statutes shall require a strong vote of at least two-thirds of the remaining capital, whether they exist or not. Voting rights or such a large proportion of shares as specifically provided in the consolidation articles for the amendment, repeal, or cancellation of any of the above provision at a meeting called objective.
Section 104. Deadlocks. Notwithstanding any contrary provision in the articles of incorporation or bylaws or agreement of stockholders of a closed corporation, if the directors or stockholders are so divided respecting the management of the corporation's business and affairs that the votes required for any corporate action cannot be obtained, with the consequence that the business and affairs of the corporation can no longer be conducted to the advantage of stockholders generally. The Security and Exchange Commission, upon written petition by any stockholder, shall have the power to arbitrate the dispute. In the exercise of such power, the Commission shall have authority to make such order as it deems appropriate, including an order, first, cancelling or altering any provision contained in the Articles of Incorporation, bylaws, or any stockholders' agreement. Second, cancelling, altering, or enjoining any resolution or act of the corporation or its board of directors, stockholders, or officers. Third, directing or prohibiting any act of the corporation or its board of directors, stockholders, officers, or other person party to the action. Fourth, requiring the purchase at their fair value of shares of any stockholder, either by the corporation regardless of the availability of unrestricted retained earnings in its book or by the other stockholders. Fifth, appointing a provisional director. 6. Dissolving the corporation. Or last, granting such other relief as the circumstances may warrant. A provisional director shall be an impartial person who is neither a stockholder nor a creditor of the corporation or of any subsidiary or affiliate of the corporation, and whose further qualifications, if any, may be determined by the Commission. A provisional director is not a receiver of the corporation and does not have the title and powers of a custodian or receiver. A provisional director shall have all the rights and powers of a duly elected director of the corporation, including the right to notice of and to vote at meetings of directors, until such time as he shall be removed by order of the Commission or by all the stockholders. His compensation shall be determined by agreement between him and the corporation subject to approval of the Commission, which may fix his compensation in the absence of agreement or in the event of disagreement between the provisional director and the corporation.
In Section 104, if the company and its operations are managed by directors or shareholders who are so split that the votes required for the company's actions are not acquired, the firm and its activities can no longer be beneficial.
Section 105. Withdrawal of stockholder or dissolution of corporation. In addition and without prejudice to other rights and remedies available to a stockholder under this title, any stockholder of a closed corporation may for any reason compel the said corporation to purchase its shares at their fair value, which shall not be less than their par or issued value, when the corporation has sufficient assets in its book to cover its debts and liabilities, exclusive of capital stock, provided that any stockholders of a closed corporation may be written petition to the Securities and Exchange Commission, compel the dissolution of such corporation whenever any of acts of the directors, officers, or those in control of the corporation is illegal, or fraudulent, or dishonest, or oppressive, or unfairly prejudicial to the corporation or any stockholder, or whenever corporate assets are being applied or wasted.
And last, according to Section 105, any shareholder of a closed company may, upon written request from the Securities and Exchange Commission, compel the dissolution of such company as one of the illegal, fraudulent, or fraudulent act of directors, officers, or those controlled by the corporation as a shareholder, or if the corporation's assets are defective or dishonest.
Now let's discuss the Title 13 Special Corporation. Chapter 1 Educational Corporations. On Section 106 Incorporation, educational corporations shall be governed by special laws and by general provisions of this code. On Section 107, Prerequisites to Incorporation, except upon favorable recommendation of the Ministry of Education and Culture, the Securities and Exchange Commission shall not accept or approve the articles of incorporations and bylaws of any educational institution. In this regards, without the recommendation of the Ministry of Education, the Securities and Exchange Commission shall not accept or approve the articles of any educational institution. Section 108 Board of Trustees. Trustees of educational institution organized as non-stock corporation shall not be less than 5 nor more than 15, provided, however, that the number of trustees shall be in multiples of 5, unless otherwise provided in the articles of incorporations on the bylaws. The Board of Trustees of incorporated schools, colleges, or other institution of learning shall, as soon as organized, so classify themselves the term of office of 1/5 of their number shall expire every year. This means that less than 5 nor more than 15 can only be the trustees or the Board of Trustees in educational corporations. Trustees thereafter elected to fill vacancies occurring before the expiration of particular term shall hold office for the unexpired period. Trustees elected thereafter to fill vacancies caused by expiration of term shall hold office for 5 years. A majority of the trustees shall constitute a quorum for the transactions of business. The power and authority of trustees shall be defined in the bylaws. For institutions organized as stock corporations, the number and term of directors shall be governed by the provisions of non-stock corporation. A trustees who's been filled a vacancies before the expiration shall only hold for the unexpired period. However, if a trustee is elected thereafter by the expiration of term, he or she may hold the office for 5 years. The following examples are the Lyceum of the Philippines University. Next is the Science Technology Institute. And lastly, of the examples is the Far Eastern University.
Religious corporation. A religious corporation is a type of religious non-profit organization which has been incorporated under the law. Often this type of corporation are recognized under the law on a subnational level. For instance, by a state or province government. Section 107. Classes of religious corporation. Religious corporation may be incorporated by one or more persons. Religious corporation may be classified into corporation sole and religious societies. For the purpose of administering and managing of any religious denomination, a corporation sole may be formed by a chief archbishop. Next is Section 108, Corporation Sole. For the purpose of administering and managing as trustee the affairs, property, and temporalities of any religious denomination, sect, or church, a corporation sole may be formed by the chief archbishop, bishop, priest, minister, rabbi, or other presiding elder of such religious denomination, sect, or church. Some examples of corporation sole include the Minister of Agriculture, the Minister of Health, the Postmaster General, the Crown, and the ecclesiastical corporation such as bishop. Since a corporation sole succession is perpetual, its capacity are granted to the individual holding office and future successors. Section 109, Article of Incorporation. In order to become a corporation sole, the chief archbishop, bishop, priest, minister, rabbi, or presiding elder of any religious denomination, sect, or church must file with the Commission Article of Incorporation setting forth the following. First, that the applicant, chief archbishop, bishop, priest, minister, rabbi, or presiding elder represent the religious denomination, sect, or church which desire to become a corporation sole. Next, that the rules, regulation, and discipline of religious denomination, sect, or church are consistent with the becoming a corporation sole and do not forbid it. Next, that such chief archbishop, bishop, priest, minister, rabbi, or presiding elder is charged with the administration of the temporalities and the management of the affairs, state, and properties of religious denomination, sect, or church within the territorial jurisdiction so described succinctly in the Articles of Incorporation. Next, the manner by which any vacancy occurring in the office of the chief archbishop, bishop, priest, minister, rabbi, or presiding elder is required to be filled according to the rules, regulation, or discipline of religious denomination, sect, or church. And the place where the principal office of the corporation sole is to be established and located with the place must be within the territory of the Philippines. The Articles of Incorporation may include any provision not contrary to law for the regulation of the affairs of the corporation. Next, Section 110, Submission of the Articles of Incorporation. The Article of Incorporation must be verified by the affidavit or affirmation of the Chief Archbishop, Bishop, Priest, Minister, Rabbi, or Presiding Elder, as the case may be, and accompanied by a copy of Commission Certificate of Election or Letter of Appointment. All temporalities, estate, and property of the religious denomination, sect, or church administered or managed as such are to be personally held in trust as a corporation sole. Section 111, Acquisition and Alienation of Property. A corporation sole may purchase and hold real estate and personal property for its church, charitable, benevolent, or educational purposes. Maaaring tumanggap ng mga pamana o regalo para sa mga naturang layunin. Maaaring ibenta o isangla ng naturang corporation ang real property na hawak nito sa pamamagitan ng pagkuha ng order mula sa Regional Trial Court, kung saan matatagpuan ang property. Ang application para sa leave to sell or mortgage ay dapat gawin ng Chief Archbishop, Bishop, Priest, Minister, Rabbi, or Presiding Elder na kumikilos bilang isang corporation. Section 112, Filling of Vacancies. The successor in office of any Chief Archbishop, Bishop, Priest, Minister, Rabbi, or Presiding Elder in a corporation sole shall become the corporation sole on their accession to office. The person or persons authorized by the rules, regulation, or discipline of religious denomination, sect, or church represented by the corporation sole shall exercise all the power and authority of the corporation during such vacancy. So, filling vacancy means an appointment, re-employment, promotion, or transfer of an officer to a vacant position. Section 113, Dissolution. A corporation sole may be dissolved and its affairs settled voluntarily by submitting to the Commission a verified declaration of dissolution setting forth. So first, the name of the corporation. Next is the reason for dissolution and winding up. Next, the authorization for the dissolution of the corporation by the particular religious denomination, sect, or church, and the names and addresses of the person who are supervise the winding up of affairs of the corporation. Upon approval of such declaration of dissolution by the Commission, the corporation shall cease to carry on its operation except for the purpose of winding up its affairs. Section 114, Religious Societies. A religious society is the incorporated congregation of religious group. An incorporated congregation or religious group acts as a legal person that exists separate and apart from its members. Religious group can be churches, volunteer groups, services groups, megachurches, cults, sect, or interfaith organization. These are some examples of religious organizations.
Chapter 3. One-Stock Person. One-Stock Corporation. Section 115. Applicability of provisions to one-person corporations. The provisions of this title shall primarily apply to one-person corporations. Other provisions of this code apply suppletorily, except as otherwise provided in this title. Section 116. One-person corporation. A one-person corporation is a corporation with a single stockholder, provided that only a natural person, trust, or an estate may form a one-person corporation. Banks and quasi-banks, pre-need, trust, insurance, public and publicly listed companies, and non-charactered government owned by controlled corporations may not incorporate as one-person corporations, provided further that a natural person who is licensed to exercise a profession may not organize as a one-person corporation for the purpose of exercising such profession except as otherwise provided other special laws. Section 117. Minimum capital stock not required for not one-person corporation. A one-person corporation shall not be required to have a minimum authorized capital stock except as otherwise provided by special law. Section 118. Articles of Incorporation. A one-person corporation shall file articles of incorporation in accordance with the requirements under Section 14 of this code. It shall likewise substantially contain the following. If the single stockholder is a trust or an estate, the name, nationality, and residence of the trustee, administrator, executor, guardian, conservator, custodian, or other person exercising fiduciary duties together with the proof of such authority to act on behalf of the trust or estate, and the name, nationality, residence of the nominee and alternate nominee, and the extent, coverage, and limitation of the authority. Section 119. By laws, the one-person corporation is not required to submit and file corporate bylaws. Section 120. Display of corporate name. A one-person corporate shall indicate the letters OPC either below or at the end of its corporate name. Section 121. Single stockholder as director, president. The single stockholder shall be the sole director and the president of the one-person corporation. Section 122. Treasurer, corporate secretary, and other officer within 15 days from the issuance of its certificate or incorporation. The one-person corporation shall appoint a treasurer, corporate secretary, and other officer as it may deem necessary, and notify the commission thereof within 5 days from appointment. The single stockholder may not be appointed as the corporate secretary. Section 123. Special functions of the corporate secretary. In addition to the functions designated by the one-person corporation, the corporate secretary shall be responsible for maintaining the minutes book and or records of the corporation, notify the nominee or alternate nominee of the death or incapacity of the single stockholder, which notice shall be given no later than 5 days from such occurrence. Section 124. Nominee and alternate nominee. The single stockholder shall designate a nominee and an alternate nominee who shall, in the event of the single stockholder's death or incapacity, take the place of the single stockholder as director and shall manage the corporation's affairs. In case of death or permanent incapacity of the single stockholder, the nominee shall serve as director and manage the affairs of one-person corporation until the legal heirs of the single stockholder have been lawfully determined, and the heirs have designated one of them or have agreed that the estate shall be the single stockholder of the one-person corporation. Section 126.
Change of nominee or alternate nominee. The single stockholder may at any time change its nominee and alternate nominee by submitting to the Commission the names of the new nominees and their corresponding written consent. For this purpose, the Articles of Incorporation need to be amended. Section 127. Minute Book. A one-person corporation shall maintain a minutes book which shall contain all actions, decisions, and resolutions taken by the one-person corporation. Section 128. Records in lieu of meetings. When action is needed on any matter, it shall be sufficient to prepare a written resolution, signed and dated by the single stockholder, and recorded in the minutes book of the one-person corporation. The date of recording in the minutes for all purposes under this code. Section 129. Reportorial requirements. The one-person corporation shall submit the following within such period as the Commission may prescribe. Annual financial statements audited by an independent certified public accountant, provided that if the total assets or total liabilities of the corporation are less than 600,000 pesos, the financial statement shall be certified under oath by the corporation's treasurer and president. A report containing explanations or comments by the president on every qualification, reservation, or adverse remark or disclaimer made by the auditor in the latter's report. A disclosure of all self-dealings and related party transactions entered into between the one-person corporation and the single stockholder. And last, other report as the Commission may require for the purpose of this provision, the fiscal year of a one-person corporation shall be that set forth in its articles of incorporation or in the absence thereof the calendar year. Section 130. Liability of single shareholder. A sole shareholder claiming limited liability has the burden of affirmatively showing that the corporation was adequately financed. Where the single stockholder cannot prove that the property of the one-person corporation is independent of the stockholder's personal property, the stockholder shall be jointly and severally liable for the debts and the other liabilities of the one-person corporation. Section 131. Conversion from ordinary corporation to one-person corporation. When a single stockholder acquires all the stocks of an ordinary stock corporation, the latter may apply for conversion into a one-person corporation, subject to the submission of such documents as the Commission may require. If the application for conversion is approved, the Commission shall issue a certificate of filing of amended Articles of Incorporation reflecting the conversion. The one-person corporation converted from an ordinary stock corporation shall succeed the latter and be legally responsible for all the latter. Section 132. Conversion from one-person corporation to an ordinary stock corporation. A one-person corporation may be converted into an ordinary stock corporation after due notice to the Commission of such fact and of the circumstances leading to the conversion, and after compliance with all other requirements for stock corporations under this code and applicable rules. In case of death, if the single stockholder, the nominee or alternate nominee, shall transfer the shares to the duly designated legal heir or estate within 7 days from receipt of either an affidavit of heirship or self-adjudication executed by a sole heir, or any other legal document declaring the legal heirs of the single stockholder, and notify the Commission to the transfer. Within 60 days from the transfer of the shares, the legal heirs shall notify the Commission of their decision to either wind up and dissolve to the one-person corporation or convert it into an ordinary stock corporation. And lastly, the ordinary stock corporation converted from one-person corporation shall succeed the latter and be legally responsible for all the latter's outstanding liabilities as of the date of conversion.